This guy walks in absolutely convinced he doesn't need a lawyer. Sure, self-representation is your right, but 9 times out of 10, it's a straight path to disaster. The judge sees it coming a mile away, is bracing himself because he knows this isn't going to be a clean legal defense. It's about to turn into pure courtroom chaos, and the tone is set before the first argument even starts.
Mr. Greco?
Yes.
Mr. Lanto would like to, he's not going with any House counsel. He is wishing to represent himself. So today's the date and time set for the arraignment and pretrial. He is in prosecutor room 1.
Okay. All right, very good. I'll be there.
Yeah. I'll be there.
Don't think I made any headway with Mr. Greco.
Mr. People versus Lanto.
Your Honor, David Greco here on behalf of the City of Taylor.
And Mr. Lanto, your name for the record, please.
Well, I'm here in a conference room. Can I just come into the court?
If you'd like to, yeah, sure.
Okay, let's do this.
I'm bringing the recording up here. Hello. Morning. Good morning.
Morning. First, I'd like to recall the case of City of Taylor versus Joshua Lanto, case number 2022-22-2024-OM-OM. That case was dismissed without prejudice, which is against my wishes, and which is why I chose to speak for myself in the court of law today. Just let me know when you're ready.
Yeah, I'm just
Appreciate that.
on the technical.
And it goes off the rails almost instantly. Instead of focusing on the actual charges, he starts digging up some old dismissed case like it's going to save him. Judges can't stand that. It's irrelevant, and it signals that he's completely off track. Court isn't therapy for past cases. It's about the matter in front of you. Bringing up baggage just screams unprepared and undermines any chance of being taken seriously.
Your constitutional rights.
And one of those constitutional rights that you explained to me is that I have the right to be informed of the cause and nature of charges. And my point
That's correct, and that's why I just told you that you were, the count 1 is alleged that you violated City Ordinance 32-31, commonly known with interfering with police authority. If you'd like me to read the expanded complaint, I can read the expanded complaint to you.
Well, may I just speak without being interrupted for a minute?
First off, I'm not interrupting you. Second, I'm just making sure that things are procedurally done correct. Third, I'm going to advise you that anything you say can and will be used against you. You do have a right to remain silent.
I understand.
So if you choose to say anything.
Well, the reason I'm asking questions about the cause and the nature of the charges is because on the last case that got dismissed, it was clear
You
that
got to stop referencing the last case because that's a separate case. Whatever happened with
we
that
have the
case,
same thing going on in this case. We have a similar situation in this case, whereas I don't know if the prosecutor understands the cause and the nature of the charges because he had to dismiss the last case.
Yeah.
Right?
Well,
So
I'm about to then let me read the complaint to you.
Okay.
Let me make sure you get a copy of the complaint.
Right. And I saw your YouTube channel on I saw your video on YouTube.
First off, it's not my YouTube channel. It's something that's forced upon me that I'm required to do because there's a court order signed by my chief judge. I prefer to do all my cases in person, but I'm required to broadcast them live because.
Well, I certainly any government entity willing to use transparency to put the truth on the table is 100% on the favor for it because
I don't have anything to hide. I don't do anything wrong. I don't have any.
You did explain factual evidence of jurisdiction, though, and you did explain it for about the better part of a half hour to a guy. Last time I was on Zoom, I was told I was crazy for talking like that.
You didn't understand me, so.
Right, but I was told I was talking crazy for asking for it.
No, not at all.
Okay, so I'm not crazy. Okay, that's first and foremost.
You can always challenge jurisdiction. Jurisdiction is something you can even challenge for the first time on appeal. One of the only things you can challenge for the first time on appeal.
Well, luckily we have about 160 people watching this right now that have heard that for the first time that probably don't understand.
This is where it really gets wild. He dives straight into the sovereign citizen playbook, challenging jurisdiction like that's some magic bullet. Then, out of nowhere, he He calls out that the hearing is being streamed on YouTube, like that's his ace card. The judge isn't impressed. He fires back with a sharp jab about people who binge-watch Law and Order or skim Google and suddenly think they're legal experts. It's funny, but you can hear the irritation. The judge has seen this amateur routine way too many times.
All right, so it is alleged that on November the 17th, 2022, that you violated City Ordinance, Chapter 32, Article 2, Section 32-31, interfering with police authority, which states, it shall be unlawful for any person within the city to resist any police officer, any member of the police department, or any person duly empowered with police authority while in the discharge or apparent discharge of their police authority duty, or in any way to interfere with or hinder the police officer or member of the police department in the discharge of the police authority duty.
And
It is
just a
alleged-
quick objection, just a point of clarification.
There's no objection to that because that's just that is the ordinance.
Okay,
Literally
if you're
read the
just reading it
ordinance
into the record, I
I
understand.
don't read the ordinance. That's
Yeah, I just want to know what in any way means in this charge. What does
Again-
in any way mean?
Again, I can't answer that question because for me to answer that question would be me giving you legal advice. If you want to file a motion, you can more than welcome to file a
Yeah,
motion.
because in any way
And I can
seems
make a
awfully
rule.
vague and it seems obtuse and it seems like it's just
These are all
impossible to.
great things that somebody might want to argue in a motion.
Yeah, it seems impossible to determine what in any
So,
way.
but if you could, please don't interrupt me until I get down to the bottom here because I want to let you know exactly what the allegations are against you from a factual basis. These are the reasons that the warrant was signed, because I found that there was probable cause that a crime was committed and probable cause that you were the one who committed the crime, hence why the warrant was placed into existence in the first place. It is alleged that on the above listed date, which was the 11/17 of 22, at approximately 2:50 p.m., you, the defendant, Mr. Lanto, engaged in a repeated course of conduct to interfere with Officer Andrew Borg's discharge of his authorized duties, which include traffic enforcement on South Telegraph Road near Ecorse Road in the city of Tampa. You, Mr. Lanto, allegedly had unlawful actions, including following Officer Borg on multiple traffic stops, approaching the traffic stops in close proximity to Officer Borg and his vehicle and the drivers, yelling obscenities and insults at Officer Borg, and video recording Officer Borg while inside of his patrol vehicle while he was accessing protected lien information concerning the drivers that were pulled over. It's also alleged, Mr. Lanto, you were ultimately arrested after Officer David Jones witnessed you walking within close proximity to Officer Borg's vehicle during a traffic stop and attempting to video record Officer Borg while he was inside his patrol vehicle accessing lien information about the driver. In count one, more specifically, in count one, the violation of section 32-31, interfering with the police authority, you, Mr. Lanto, the defendant, allegedly approached the traffic stop at approximately 3:04 p.m. and interfered with Officer Borg by being in close proximity to Officer Borg, his patrol vehicle, and the pulled over driver in the center median of Telegraph Road and yelling and hurling insults and obscenities while Officer Borg was discharging his police authority duty. In count two, violation of section 32-31.
Here the judge finally lays out what's actually on the table, and it's serious business. We're talking about accusations of tailing cops during traffic stops, hurling insults, and filming as officers pull sensitive driver data. That's not just disruptive, it creates a situation that can turn dangerous in seconds. The judge chooses his words carefully, making it clear this isn't about harmless protest, it's about actions that push the limits of safety and legality.
Clarification before I make an informed.
This isn't a matter of clarifications. This is you either pleading guilty, not guilty, or standing mute.
Well, I was told I have the right to be informed of the cause and the nature of the charge.
Just did.
You just read this into the record and all it did was confuse.
I did.
So, because we have right in here that Officer I was told
Listen,
I was
I'm
in
not-
close proximity of
Sure.
Officer Borg.
I'm not
What
going to
is-
get
what
into
is
the
close
particulars.
proximity?
Listen, I'm not going to get into the particulars. This isn't the trial. This is nobody's sworn in under oath. There's a subject to cross-examination by both sides. That's what trials are for.
Okay,
That's what trials are for.
before I make an
This is
informed.
just these things. So I'm going to give you 5 seconds to either choose. If you're not responsive, then I'll just enter a plea of not guilty so that your not guilty status is preserved and your constitutional rights preserved there as well.
Well,
So how do you plead? Guilty, not guilty?
I object for clarification.
Sure. Guilty or not guilty?
Well, I object to that because I can't make an informed plea today.
All right, then I'm gonna
Unless I have- unless I have
enter a plea of
discovery,
not guilty on your behalf. So you're still not guilty on your behalf, and
And here's the breaking point. The judge asks the simplest question, guilty or not guilty. But instead of answering, he stalls, spins, and talks in endless circles. Judges hate this because court runs on clarity, not debate marathons. When a defendant refuses to cooperate, the system doesn't wait. It enters the plea and moves forward without them. It's a harsh reminder that playing games with procedure only digs your hole deeper.
I'm not going to get into a civil procedure class here. I have other cases to do. You've been advised in the premises of what the charges are against you. I'm finding you're unresponsive as to guilty or not guilty, so I am going to put in a plea of not guilty.
And I have to object to that on the record.
Sure, it's on the record. And now, if you don't want to speak with Mr. Greco at this time, then you're more than welcome to leave, and you'll be given a notice as to moving forward. I can set this up for a settlement conference, or we can just set it directly for a trial.
Okay, and then the next time we're here, we'll be able to recall the old matter, so I can get
I can't
reimbursed.
answer that question because that may be me giving you legal advice.
Okay.
When I'm wearing
I think
this
Mr.
robe,
Greco should
when
be
I'm
on the
wearing
hook
this
for-
robe,
Yeah.
it's like being a referee. I can throw a flag, blow a whistle, but I can't coach either team.
Yeah.
I can't tell you how to proceed or what manner you should proceed.
Well, you spent about a half hour explaining it to somebody else.
No, I explained to them.
Well, it was a formal motion.
I wasn't giving them legal advice. I was
Yeah.
merely explaining what jurisdiction means. They had already said in their motion, they had filed a motion
Right.
stating each individual
I watched
reason.
it. Yeah, I watched it. I pay attention. I'm actually here to look for areas we can find agreement.
But then that's someone you need to talk to Mr. Greco about.
Well, I don't think he's willing to find agreement.
You're not going to find, with
So he's
me,
going to have to litigate.
with me, agreement comes from because the two parties approach me with an agreeable situation that they want to put on the record, in the form of a plea or a dismissal, or I can do a trial and I let the facts that are all under oath speak for themselves.
Well, and when I saw the mob boss judge, he actually had a different case, and he was actually a lot more fair than I originally gave him credit for. So the mob boss judge, I'm glad he's not here, but he's the one that he's the one that told me I would be assigned an armed.
Well, first off, I don't find I find it disrespectful to refer to somebody as a mob boss. That's because that literally is,
That's how it felt to me.
well, what I'm saying is you just libeled somebody.
Well, that's how it felt.
And then it just explodes. He crosses the ultimate line by calling another judge a mob boss, and that's when the lid blows off. You can feel the energy in the room shift as the judge snaps and shuts it down instantly. There's a world of difference between defending yourself and outright disrespect, and the moment he said that, the judge made sure this circus act ended cold. Courtroom order isn't optional. Cross that line and the hammer falls hard.